Before we formally begin, let me ask a simple question. Whenever a legal dispute arises, what is the first solution that comes in our brain? For the most of the people, the answer is straightforward to going to court. But now, today's legal and commercial landscape, are courtrooms always the only solution? Can disputes be solved faster? Can business avoid years of litigation and still obtain effective remedies? The answer lies in the alternative dispute resolution, commonly known as ADR. Over the last decade, ADR has transformed the dispute resolution ecosystem, becoming an essential part of the legal practice not only in India but across the world. For aspiring lawyers, understanding ADR is no longer optional, it is becoming a professional necessity. Today's session is designed to help you understand this growing field and opportunities it offers beyond traditional litigation. Today's webinar is organized by Collective Counsel, a platform which is dedicated to bridging the gap between the legal education and the legal practice through the practical learning initiatives like the mentorship opportunities and the career focused training. Our objective is simple to help the law students and young professionals develop practical legal skills that complement their academic learning and preparing them for the profession. So it is now privilege to introduce our esteemed speaker for today's session. Advocate Chirag Dev sir is a practicing advocate based in Pune with over 6 years of experience in the legal profession and is currently associated with a law firm. He also proposes valuable experience in the compliance industry where he has advanced and worked closely with corporate clients on various legal and regulatory matters, and he have primarily focused on corporate advisory administration proceedings, nclt matters and much more. Apart from this, his practical and solution oriented approach makes him an ideal mentor for today's discussion. Without any further delay, I would like to handle the session to Chirag sir. Over to you, sir.
Good evening, all. I hope my screen is visible to everybody.
Yes, sir.
Yes, sir.
Yeah. Am I clearly audible and visible to everyone?
Yes, sir, you are.
Yeah. So I think let's start with our webinar. Basically, you all are aware about this topic, that is the ADR practice, the way it is booming in India. Now, directly coming on to this course, before the understanding of this course, let us first understand the basics of ADR and what this course is going to give us. Now, in the legal fraternity, we know like laws changes, things are changing every day, some new things are coming up. So now in this particular field, litigation is one of the area where the disputes are still going on, and because of the huge pendency on the court, the traditional way of litigation or the dispute resolution becomes a tiresome and tedious job. Hence, to overcome that, these days the approaches of businesses or the concerned people is transforming towards the ADR practice, that is alternate dispute resolution. Now, this is particularly a course based on what is ADR, specifically focusing upon the practice of arbitration. Now, let us first understand why ADR matters today. So, as we all know, there is a huge pendency in the court. If we count the number of cases in the trial court, district court, the high courts, as well as the Supreme Court, the pendency is going on. The reason for this is the ratio of population versus the ratio of judges differs a lot. There is there is no ideal ratio in India. This is one of the biggest issue. Second is the procedural part. That is, generally in the civil code we follow the CPC, civil procedure code, when it comes to a normal civil dispute. So when we learn CPC, the procedures are very tedious and tiresome, and it makes the system ineffective to deal with the practical issues. No doubt that things are changing, few things are coming up. For example, after COVID, the courts have switched on to virtual medium as well. This is one of the biggest development and change which we are seeing. In fact, today arbitration meetings are continuously virtual, or unless and until the parties actually want to meet up for the cross examination. Otherwise, everything is virtual and final order is given on email. This we have, like, we are practicing this. This is actually saving time, saving efforts, saving money, saving resources. Okay. So today there is a huge pendency in the court. This is one of the first reason. Secondly, there are growing businesses. The way technology is growing, the way new things are coming up in the market, the way businesses are dealing. Okay, so it has become important for all the concerned party to have arbitration clauses in their agreement. This is again very important aspect. Now we are going to talk from the practical point of view, but I'll just take you all a step back. Now, what is this that particular step? That step is when you are actually practicing in contract management, or when you are drafting any type of agreement, whether it is an employment agreement, whether it is a joint venture agreement, whether it is development agreement, whether it is consultancy agreement, any and every kind of agreement, you will have to be careful while drafting the dispute resolution clause. Now, this is again very important. Now, why this matters? Today, the way arbitration practice has boomed. Now, for example, earlier we had the Arbitration Conciliation Act of 1940. It has to be changed, and the 1996 Act was brought. From 1996, today we are in 2026. Things have changed very rapidly. Now, there were amendments brought, there are amendments proposed. Down the line, we are going to see many more changes. But now, again, it is again very important to understand how the commercial contracts are dealt with. Let me give you an example. A client comes to you asking for my XYZ amount is to be recovered from the opposite party. Now, what should be our first approach? We first need to understand the transaction. We first need to understand what are documents exchanged. Directly, we cannot advise that go for civil suit for recovery. Issue a legal notice, go for civil recovery. Now, generally, when clients ask, what is the timeline you are expecting? Now, as a lawyer, practically, we cannot commit any timeline. कि within 3 years, case will be closed. Within 4 years, we'll assure that आपका पैसा मिल जाएगा. This cannot be assured at all, because civil litigation takes 10 to 12 years minimum if things are happening in the normal recourse. Otherwise, it will go on. As I told you, the reason for this is again the procedural part, the pendency, transfer of judges, notices are not being served to the opposite party on time, they are not appearing. All these things are very practical issues. So, again, coming back to what type of contract we are drafting, different from the legal perspective. So, for ADR, from the practical point of view, first of all, we need to go back to the clause. Now, when you are going to actually study this course, when you are going to take up this, the very first or essential element to initiate ADR or the arbitration is basically the first is the important thing is the arbitration clause. Okay. Now, let me give you another example. These days, we have to be very careful when we are drafting the arbitration clause. So we cannot directly ask the client to jump onto arbitration, because there are few stages. For example, these days, if you will see, if there is any dispute between the parties, first they are going to try to amicably resolve among themselves. This is the very first remedy. Okay. Second will be, if they are unable to resolve, then they will go for mediation. Okay. If mediation fails, then parties are at the liberty to invoke arbitration. So these are pre-arbitration stages. So each have multiple facets. Arbitration is completely different. Mediation is completely different. Conciliation is completely different. All different facets are there. So in this particular course, you are going to have a proper idea as to what is the purpose of respective aspect. Next is rising demand. So the growth of institution and international arbitration ADR is essential in the legal profession these days. Now, if you see today, the approach of businesses is growing towards ADR. Why? Because first of all, it is less time consuming. Secondly, uh, in quick time. Okay, this is the important thing. Secondly, there is confidentiality which is maintained among the parties. Now, when it comes to a normal litigation, once the case is filed, things become very open. Anytime you can access the e-portal, access the data of the respective company. So now arbitration maintains that there is confidentiality among the parties. So not only these, there are multiple things which are necessary for us to understand ADR, because the way things are changing in the legal profession, various new elements will be added. Coming back to the next aspect, what is ADR? Now, as we have discussed, alternate dispute resolution. Okay, now this, in simple terms, is basically a method of resolving the dispute apart from the normal traditional, which is the legal recourse in the court of law. So arbitration generally helps the parties to resolve their dispute out of the court. Now, in under ADR, we have various aspects. That is, first is arbitration, mediation, negotiation, conciliation, online dispute resolution, and various other forms. One of the example. Is anybody aware about MSME, micro, small, medium enterprises? Any idea? Anybody? Have you heard about MSMEs? Okay. MSME is basically micro, small, medium enterprises. So these are small entities wherein you have to register under the MSME. These are regulated by a specific law that is called as Micro, Small, Medium Enterprises Act. Okay. Now specific laws are enacted to help the small businesses to grow. So these businesses can register themselves under the category either micro, small, or medium. Now the recovery mechanism has been mentioned under that particular act. For example, if you are registered under MSME and your XYZ amount is still pending from the party to be recovered, so in that case, you can file an application before the MSME tribunal under that particular act rather than going for the normal civil recovery. Now, why? Because they have got a legal or statutory framework. So under MSME law, it becomes easy for the party to approach the MSME Facilitation Council. Now, the best part under MSME is, first of all, they will is to try to resolve the dispute among themselves. If they are unable to resolve, then a conciliation officer will be appointed. That conciliation officer will try to negotiate among the parties. They will ask to come to a conclusion within a period of 90 days. If that is failing, in that case, it will be referred to arbitration. Okay, so now there are multiple stages under the MSME as well. So after conciliation, it will go to arbitration. If arbitration, in that case, the arbitral tribunal will decide the matter on merits. Okay, so various laws have given these particular various types of resolution and dispute mechanism to resolve the dispute effectively rather than going to the normal recourse. I hope things are clear until now. Let's move on to the next part. Yes, about the course. Now, as a law student, generally we do study whatever subjects are there as a part of our academics. But sometimes we need to connect those things with the practicality as well. So this course, that is ADR, is will give you a practical insight as to how the proceedings are conducted, what are the essential elements which are required to be understood when it comes to filing the statement of claim, filing the statement of defense, when it comes to cross examination, submission of evidences. All these things become very important. Now, this particular course is again designed for law students and fresh graduates, young advocates and junior advocates, in-house and corporate legal professionals. Now, again, let me give you, an insight as to why it is important for in-house as well. So generally, when we enter into a legal profession, when we start our law journey, after the completion of 5 years or 3 year law course, wherever we are, many of the students will have this thought in their mind, okay, where I have to go. I don't know what should I do in my career, which area should I focus on. Okay, these are very general issues. But what I always advise students is, during your course, you need to understand what are the challenges of the field. Once you get to know about those challenges, try to overcome those challenges. Now, in fact, we have seen examples where students are already graduate. They have completed their 1 year after graduation, but still they are blind as to where we have to go. So, in that case, such things become important to know your pathway. Now, for example, many of these students will have this idea to go into practice area. So, with the court litigation, they will also learn other facets. Some of them will go to in-house job. Okay, so now what we generally advise all the students, if you are even going to an in-house counsel role, again have to understand what is the actual process which is being followed. So for that purpose, this course again becomes very important. Now, what are the objectives of this course? First is understanding the ADR legal framework. So how the Arbitration Conciliation Act is framed, what are the important provisions under the act? This will be one of the important part. Next is learning practical arbitration procedures. So as I told you, the provisions along with the procedure and practical issues which are coming up. Next is this will again help to develop drafting and advocacy skills. Again, very important. Understanding the arbitral strategy and how the tribunal functions. What is the way? What is the procedure which is being followed? Now, to give you an example, we are aware as to normal civil courts will have to follow CPC, that is Civil Procedure Code. However, the tribunals are not bound by CPC, not bound by Evidence Act. So they have their own procedure which can be decided by the parties. This is again one of the important merits which is available. Now, for example, in a normal civil case or a civil dispute, if I being advocate for the plaintiff, if I move an application before the honorable court for anything, so what will be the procedure followed there? Once the application is on record, the court is going to direct opposite party to file their reply. After the reply is filed, there will be arguments on that application. After the arguments are done, there will be order. This is the procedure. Now, when we speak about this process, it's look very simple. I am filing application, opposite file party will file reply, there will be arguments and order will be passed. However, what we have seen practically is this processes also take a period of 1 year or 2 year or so, because many of the time the advocates of the respondents are reluctant. They are missing the dates. They are just taking the date but not appearing before the court. These are all practical problems which are always coming up. However, in case of arbitration, it is not necessary for parties to always file the replies unless and until the parties actually want to. This helps the procedure to to save the time of all the parties as well as the tribunal. Hence, one of the important aspect and how tribunal is generally functions. Next is this will again help us to gain dispute resolution. Very important. Because normal traditional court practice can be studied when we are appearing before the courts, and arbitration is again one of the important element in the legal profession. So this course is definitely going to help to achieve these objectives. Moving on to the next part, the key learnings. So this course is actually drafted, or the modules which are available under this course are covering whole arbitration act, which will again give you insight with respect to practicalities as well. So first element is drafting. So now as a drafting is necessary right from drafting the arbitration clause. Now, when we say arbitration clause, how arbitration can be invoked in two ways: by having a specific arbitration agreement in place, or by having a clause in any agreement. This is general perspective. So now drafting of that clause is important. Why that is important? Many a times the courts have rejected reference to arbitration. Why? Because the clauses are vague. These are the examples. Okay. So in this particular course, you will study as to how arbitrations can be invoked. Very important. What is the implication of limitation period? What is the jurisdiction of the tribunal? To what extent the courts will interfere? Powers of the courts. Everything is very important and important for us to understand. Recently, if you see, since the year 2023, 24, 25, we have seen so many Supreme Court cases giving so many new rulings. Okay, why? Because people are changing their perspective towards not from the normal but being set. Okay, so again, drafting is very important. Now, drafting, what are the important aspects? First is your arbitration section 11 application. Then, when the arbitration actually starts, your statement of claim, statement of defense, evidence affidavit which are required to be filed. So this course will help us to understand all these key elements. Next is the procedure. Again, what is the process which is required to be followed? how to invoke arbitration notice. What is the right time to invoke the notice? What is the timeline for it? In case if parties fail to amicably appoint the arbitrator, then what are the remedies available with the parties? If they have any objection with respect to jurisdiction, what are the options available with the parties? All these are the key important things when it comes to the procedural part. The next is award. Again, as we know, the final order is called as award when it comes to Arbitration Act. Now, order is again very important aspect. When final decision is given by the arbitral tribunal, it is called as the award. So, how to enforce the award? Again, very important. Once the order is in favor of the party, this does not mean that things are closed. How to enforce it, just like a decree which is passed by a civil court? What are the provisions for it? Can we go for execution application? Okay. What will be the implication of CPC on that? Next important aspect is challenging the award under Section 34. So there are very limited ground. Like for example, in a civil case, if a trial court or a district, a civil judge has passed an order or a civil judge has given his judgment, in that case, that can be challenged before the appellate authority or the appellate court. Okay. Now the general hierarchy is from a civil court junior division, it will go to senior division. From senior division, it will go to the district court. From the district court, it will go to the high court and then Supreme Court. This is a hierarchy which is followed. However, in arbitration, we don't have appellate jurisdiction which is given to any court. It is purely Section 34 where parties who are aggrieved by the award can challenge the award only under specific grounds. Okay, so that can be challenged before the district courts. So now this is again very tricky and very important to understand because Arbitration Act itself has used the word court. Now, court does mean different in different jurisdiction. For example, if you are in Pune and you want to challenge an arbitral award passed in Pune, then district court is the right authority. If you are in some other state, there it is compulsory to file Section 34 application before high courts only. This is generally in cases of Delhi as well as Tamil Nadu. So this becomes a very important part for us to understand. So where it can be challenged, what are the grounds for it? All these things will be specifically there under the award section. Next is the recent trends. The way arbitration have changed. The way the pace of legal fraternity or legal field is changing. So the recent amendment brought in 2015, 2019, 2025 Arbitration Act, the amendment which was proposed, which referred to emergency arbitrations as well. Again, very important area which requires attention and focus of government. Civil court, if your matter is urgent, what is the remedy available with you? Go for injunction. Restrain the party from doing something. Similarly, in cases of arbitration, section 9 is basically when you want to appoint a this process takes a lot of time. It takes a time of 1 month. This mention that courts under section 9. Then, if arbitral tribunal is appointed, then section 17 is there. So, what are the powers of can interfere? All these implications are again very important. So, various changes were brought under the Act in 2015, 1921. Which is going to give an overview of all these aspects as well. Now, let us understand and discuss as to how this course is actually framed and what are the various modules available under the particular course. So, the first module is Introduction to ADR. This is again a very generalized chapter, which I'll say, which will give you a basic idea as to the meaning, types of ADR, and how ADR is evolved in India. Okay, this is again very important to understand. Next is the concept of arbitration. How domestic arbitration, how international arbitration is decided, or how it is defined under the Act. What is institutional arbitration? What is ad hoc arbitration? Again, the difference is, as I told you, arbitration again. There is a difference between seat of arbitration, venue of arbitration, okay, place of arbitration. All these concepts seems to be same for a layman, but not for us. Okay, we are students these things. If you are in Pune, you will see the ILSCA arbitration, ILS arbitration that has been established in the same premises to promote ADR practices. Secondly, you will see DIC, Delhi International Mumbai International Arbitration Center. These centers are basically established under the aegis of High Court for the parties and to administer and govern the proceedings. That is again very important and beneficial aspect. Next is in the third module, we'll understand as to what are arbitration agreements and how arbitrations can be invoked. That is again very important. Let me give you for us and may. Okay, when it comes to interpretation of shall and may. So judgments on this part. For example, if your arbitration clause specifies the word may, for example, if there is a dispute and both the parties wish to resolve it, the parties enter. If these are provision, then that is not a obligatory part on the parties to actually go for arbitration. If shall is mentioned, then in that case it becomes on the parties. These are very much small things which are very important for us to understand. I think there are questions in the chat box. If is it okay if I take the question answers at the end?
Can take that.
Right. So those who want to ask questions with respect,
Yes, sir.
yes. So, again, arbitration agreement very important. Drafting of very those things. We have fought cases where parties are taking defense as to this dispute is not arbitrary. Literally, these are correct. Everything is procedurally correct. What is the implication of again, law of limitation is very important. Law of well, for example, the limitation period for filing a civil recovery suit is a period of 3 years. Same is applicable on the arbitration process. So now the 3 years period, when it will start, how you have to count that period. Okay, there is a concept called as crystallization of cause of action. Okay, in that, like for example, suppose the parties are trying to resolve the dispute amicably. However, that is not working out. But parties have wasted almost 1.5 years in this process. So whether this period will be calculated to calculate the limitation period or not, many aspects are there. So this particular course is going to address these all practical aspects as well. Next is module the next module will talk about the appointment of arbitrator as to what are the procedure, what are the provisions for appointment, how you have to appoint, what are the important implications which are required to be complied with. Those things are also there. Substitution of arbitrator, again very important. Okay, so these are the practical aspects which this course and this module will help us to understand. The next module will talk about the arbitral proceedings. Commencement of the proceedings, filing of statements, that is statement of claim, statement of defense. So generally, if you will see or compare the stages in a civil case and stages in arbitration proceedings, there is a huge difference. As I told you, CPC is not binding on the arbitration proceedings. This is very clear. But arbitration proceedings themselves have their own process. For example, once arbitration is invoked, there is a preliminary meeting which is conducted. So both the parties, their counsels, and arbitrator meet. Generally, it is conducted virtually. In that meeting, arbitrator is just being briefed as to what is the subject matter of dispute and what are the claim amounts. Okay. Then arbitrator will direct the claimant to file their statement of claim, just the way we file plaint in civil suits. Then next is the defendant will file or the respondent will file the counterclaim or statement of defense. If he's having a counterclaim, he'll file a counterclaim or statement of defense. Before that, If he has any objection on the jurisdiction of the tribunal, then he will have to file an application before the tribunal himself. Okay, this is again very important. So jurisdictional issues, the total liberty is given to arbitrator under section 16. This is again very important part and procedural aspect. Then next comes the evidence stage. Once the evidence stage is closed, final arguments, award. Okay, these are the steps which are followed. Next module will help us to understand powers of the tribunal. Okay, what are the powers given? Because we follow a procedure where all the rights and powers are governed by the respective statute. And here the statute is Arbitration and Conciliation Act. So what are the powers given to the respective tribunal? They have to work within the limited framework which is given to them. Okay. A very interesting example I just remembered. In one of the arbitration cases which we were dealing, so the award was passed in favor of our client. Opposite party challenged that award under section 34. Okay. Now, if you when you will read section 34, there are only very limited grounds that on these grounds only you can challenge it. Those grounds are, if they think that natural justice principles are not followed, the award is against the fundamental and policy of India. These are very basic, essential things of that. So generally, every advocate will try to fit their award under those parameters. So interesting question which came up before the court was, court only wanted to know whether equity principles are being followed while passing the award or not. This was a big question. The court did not went into the pure merits because under section 34, 34 is not like a appellate provision. In appeal, court will actually go into the merits of the case, what is right and what is wrong. Under section 34, court is not going to go into the merits of the case. Court will just on the basis of award and on the basis of the grounds is going to assess as to whether award can be set aside or not. So very interesting thing which came up before the court was, court only wanted to check as to whether equity principles are followed by the arbitral tribunal while passing the award. So for that, we cited around more than 15 case laws of various high courts, supreme courts, where these principles were settled. Okay, so now this becomes very important when procedure are actually going on. So very very interesting area of practice where when the award is challenged under 34, how you will defend it, what are the important elements of that particular aspect, all these things matters a lot. So again, powers of tribunal, whether the tribunal is actually transgressing the powers, whether the orders which are passed are within their ambit or not, all these things becomes important. Again, which orders or which decisions given by the tribunals are challengeable, whether they can be challenged twice or thrice, which are the specific forums. Okay, section 37, section 34 gives us the idea about the appellate jurisdictions as well. Next module talks about the practical drafting. That is, as I told you, drafting of arbitral clause, again very important. Drafting of section 11 applications becomes very important. Along with that, once your arbitral proceeding starts, statement of claim, statement of defense, evidence affidavits, all things become important. Now, even though we are saying that CPC and Evidence Act are not purely followed, but certain principles are definitely followed. For example, there is a settled principle under law that evidences cannot go beyond pleading. I'll repeat this. Evidences cannot go beyond pleadings. Means what? Whatever you are going to write in your statement of claim or statement of defense for that matter. So whenever you are going to submit your evidence should be based on your pleadings. If there is anything which is beyond your pleadings, then those things are not permissible under law unless and until you have filed a separate application for it, for making the changes. So very small things are important. Again, let me give you an example. If you receive a legal notice or your client receive a legal notice, what will be your very first step? First step will be denying all the contentions of that notice unless you are expressly admitting it. Okay, now in the initial year of career, your careers or maybe during an internship, if you are going through any of the legal notice, you will see that why things are repeatedly mentioned that we are denying this, we are denying this, why there is a parawise reply given, why there is a parawise denial given. This becomes important when you are at the final argument stage. So now just imagine In case of civil dispute, you have filed your case in 2019. Let us take an example. You have drafted your suit in 2019. Today we are in 26 and it has come for final arguments. So just imagine, like who we are also human. Okay, who is going to remember each and every aspect of that? We have to again read it. Hence, it becomes important for us as advocate to draft it in such a way that we are, trying to save or defend our client or claim everything. Okay. So when you see, how the statement of claims and how statement of defense are drafted, practical aspects become more important. For example, denial. Okay. So if you are denying a particular fact, then you should be having a proof for it. Okay. These things become important. So this particular module will teach us about, how practical drafting is required to be completed when we are drafting the various aspects under the Arbitration Act. Moving on to the next part, that is module 9, we'll talk about the arbitral award. Okay, again very important. What should be the framework of award? It's again very basic. While any of the judge in civil case is passing any decision, reason is required to be given. Okay. Similarly, the award should be reasoned. Okay, specific reasons should be mentioned under the award. Then what are the procedure for, typographical corrections, any, finality of the award? All these provisions are already mentioned under the particular act. Next module is section 34, that is setting aside the arbitral award. What is the procedure which is followed for it? What are the grounds for it? Very important. Okay, under what parameter you can challenge the award? What is the meaning and role of section 34? Okay, just the way we know as to what is the meaning of Article 32 under Constitution and what is the meaning of Article 226. What are the powers available with the respective court under Article 32 and 226? What is the implication of Article 136, that is special leave petition? Every provision for that matter have different facet altogether. Similarly, Section 34 is altogether different. We cannot treat Section 34 just like the way an appeal is filed. Okay, there are specific requisite criterias under Section 34 as well. So this is again very important. Again, I just remembered in 2024, there was an amendment which was proposed under the Arbitration Act, and that one of the amendment was to have an appellate tribunal of the under arbitration. Okay, so today, as on date, we don't have appellate tribunal. The hierarchy is once the award is passed by the arbitral tribunal, the only remedy available with the party is to file an application under section 34. Again, I'm saying it is an application or petition. Okay, it is not an appeal. Every term for that matter is different. So when it is an application, you are asking the court to set it aside on specific grounds if those are proved. Okay. So under in 2024, this amendment was proposed to have a tribunal. Just for example, we have NCLT, National Company Law Tribunal. We have NCLT, that is Appellate Tribunal. Okay. For consumer courts also we have hierarchy: the district forum, the state forum, and the national forum, and then the Supreme Court. Similarly, it was proposed here. The only reason was to reduce the burden on courts. Here we are saying that arbitration is out of court. Purely, it has nothing to do with the court process. And when Section 34 applications are filed, the courts are burdened with it. So to do away with this step that was proposed, however, it has not brought into effect. Maybe the government is still thinking on that part. But down the line, this is definitely going to happen. That we might have a separate arbitral, tribunal which will hear the appeals. Maybe this will actually reduce the burden of the court. So under module 10, we are going to understand as to under what criteria we can challenge the award. Next is appeals and enforcement. As I told you, what is the process for enforcing your award? Secondly, how domestic awards and foreign awards can be enforced. Next is module 12, talks about the amendments and the recent trends which have changed. Amendments of 2015, 2019, 2021. The next is who should attend and career opportunities. So as I told you, ADR is going to give us, different approach altogether. Because one of the example which I discussed with you all is the MSMEs, micro, small, medium enterprise. Recently, MSME have shifted their change from normal recourse. Okay, they have now invited various arbitration institutions to get tie up with them so that matter can be directly referred to them. Okay, so this is again a evolving aspects of career where a number of career opportunities are available. Okay, so in whole of this course, you will be able to understand the criterias and the basics of alternate dispute resolution. Now, the how this will help to build your practical insights. This course will help us not only to understand the theoretical provisions but also the examples. Just give me a minute. Yes, sorry for the break. Yeah, so this course will definitely help us to understand not only the provisions, because see, as a law student, our basic should be to know the provision first. Second is to know how that provision is applied. This is very important. So reading is again very important, to read the particular act, to understand the provisions, to understand its interpretation. So this course will help us to understand the provisions along with the practical examples. And again, this will boost you to, you know, improve your CVs, which will help you to again, when it comes to an ideal CV will be there when you are adding up these additional knowledges with you. Yeah, I think that's all from my end. If there are any questions, then we can address the questions.
Thank you, sir. We'll now open for question and answer session. I think we have a question in the chat box. Sir, do you want me to read that or we shall
I'll
call
I'll
the person?
just I'll just read. I'll just go through.
Okay.
I think the first question is Arundeep Kaur, right?
Yes, sir.
Does
Before
it
that,
become bias? Yes.
yes, sir. Before that, Dhruv has asked something like MSME. So
Yeah, yeah.
I
So
think he
it's
wants.
not MSMA, it's MSME. I'll just type in the chat box. Yeah, so MSME is basically micro, small, medium enterprises. There is a specific act to this, that is Micro, Small, Medium Enterprises Act of Development Act of 2006. Okay, so these are specific entities where you can register with the government authority. Okay, so the benefits of this is once you register with the government authorities, you will get various benefits. For example, subsidy in taxation, subsidy in stamp duty which you are required to pay. Okay, there are various government schemes where you will be applicable. Secondly, the one of the important part of MSME is normally if you want to recover your money along with interest. Okay, that is very standardized at 18%. But MSME will give you specific right to recover your money at compounding rate. Okay, it is a specific provision given under the Act. So why I gave you reference of MSME, because the moment a application is filed before the MSME tribunal, it is again referred to a arbitral tribunal only. So again, it becomes important for us to know the Arbitration Act. That was about MSME. Next is, I think, sir, does it bias too in case of institutional arbitration as to a parties no to institutionalist rule? No, generally, now we are dealing with both the types of arbitration, institutional arbitrations as well as the ad hoc arbitrations. So, in case of institutional arbitration, it does not become any bias. Okay, the rules which are framed are basically to govern the relationship between the parties and the procedures. Okay, so it does not become biased because ultimately it is only the institution which is helping for administrative purpose. That's all. Otherwise, there is no role of that institution because that institution is basically a mediator between the parties and the concerned arbitrator. This is only the difference, nothing beyond it. I hope I have, clarified your doubt, Arundeep. Yes. Now, next is advice for tier 3 cities of law that how they start practice for ADR. Yes, now this is again a very tricky question. Now, these days, if you see, you will not find a specific law firm which is purely practicing into ADR. Okay, the way ADR practicing is booming in the city like Pune, also you will find multiple law firms which are handling the arbitration, cases. So your focus, when you want to actually excel into arbitration or practice arbitration, is to join law firm with the arbitration practice. Okay, they will have arbitration matters which will help you to grow and understand the proceedings there. So the only basic criteria will be you now, for example, you are a practice area, you want to focus on corporate law. Okay, so but in corporate law, where you have to grow, whether it is your mergers acquisition team, whether it is contract management team, whether it is compliance team, okay, whether it is due diligence team, this becomes difficult. Similarly, when it comes to arbitrations also, there are multiple law firms which are handling arbitration matters. And these days, the way practice is booming under arbitration, you will find at least 5 to 10 matters with every law firm. So that is only the best way for you to approach. And also stay in touch with whatever is going on. Okay, maybe you can stay in touch with the institutions if there are any opportunities, internships opportunities there, where you can closely work with the arbitrators. These opportunities are also available so that you will understand the practical insight of it. Yeah, any other question?
Participants, if you have any other questions, you can drop in the chat box, or you can speak also. If no, so we have a few questions, which are basically, I think we have a question.
Yeah, any advice for final year law student to excel in arbitration? What I would suggest final year student is, first of all, right now, if you are actually not able to practically work in the area of arbitration, like for example, you are interning somewhere, but there are no arbitration matter, because you cannot imagine the moment you enter your internship and you will get, arbitration work. So for you all, it is important for you to be thorough with the law. Stay updated with the recent changes which are going on. Stay updated with the, new judgments which are being passed. Okay, parallelly, if you are able to work, okay, or if you are able to join any firm with a arbitration practice, that will be the best thing. Otherwise, right now what I will say is, read the laws, read books, read articles with respect to arbitration, which will help you to gain knowledge on that. Yeah. Next is repeat all relevant sections in arbitration. Okay, so I refer to Article 32 and Article 136 of the Constitution. Okay, so for arbitration, the important provisions are Section 21, invocation of arbitration notice, that is for appointment of arbitrator. Section 16, challenging the jurisdiction of the arbitral tribunal. Section 34, that is challenging the arbitral award, which again gives right to the parties to enforce the award. These are very relevant and important section. One more question is, can the arbitration award be enforceable in mediation? Can you just elaborate this question? What I want to ask. Arbitration awards can only be enforced by the way of the provisions mentioned under the Act. That is only through the normal civil courts, not otherwise. So jurisdiction lies with the civil court only for execution petition. You can file execution petition for enforcement of award, and there is no other mechanism. Yes. Any other questions?
Sir, particularly added to courtroom litigator.
Once you have a normal litigation practice and you know how to handle any case of arbitration as well. Like no doubt, there are advocate directly you can jump to arbitration and start arbitration practice. That, that's the normal
Yes, ADR practice.
student right. So directly, if you want to get an exposure in arbitration proceeding as done, very fine. But your duty again is to go back, do your homework, as observed, whatever the which were referred to understand those provisions. Okay, so the misconception is like if we
Yes,
but I would say one important thing from the way arbitration is going, you need to understand the when you these become so just focus on the provisions and understand the right way.
sir. So we have two questions in chat box.
what we from mediator be enforceable. So the decision of mediator is not enforceable. It's just to conclusion. Okay, his duty is just to bring so that they can talk to each other and then they are able to resolve it or not. Okay, so the decision of mediator is not binding. Okay, first of all, the mediator will not actually give the decision. Mediator will actually the arbitral tribunal or the arbitrator is binding on the parties. Arbitration is practicing in metropolitan cities and top tier cities of India. Do you think it will be familiar in future? And those actually not now arbitration practice the MSME law as well. Okay, so down the line, because because of the technological advancement and because it is available virtually, the arbitrator is sitting in Delhi, arbitrator is in Kolkata, Madras. It is not necessary for us to go there and travel on all the days. Things are conducted virtually. Arguments on specific applications are also conducted virtually. There is no need for the parties to go because it becomes easy. Okay, and because of now these days transcript content actually administratively to grow. So talking about practice, it won't be necessary metropolitan city or top cities only these things are practiced. It will be a part where other things are coming up. Now, no doubt, where business transaction take place, there only there is the chances of related disputes because of the virtual mode.
Yes. Thank, thank you, sir. Now the doubts from the students are clear now. Help the students on skill building, we have developed our accelerator programs. So each accelerator is designed as a complete that combines expert mentorship, job distributions, technical courses, and networking and career guidance. So, for the students who know they want to do more, grow faster, and stop figuring everything out alone, the registrations are now open. We are sharing the registration link in the chat box and in the WhatsApp group as well. If you are generally serious about building your legal career earlier, and this room was made for you. So as we come to end of today's session, I would like to extend our heartfelt gratitude to Advocate Chirag Dev sir for taking up the time to share his expertise, experience, and practical insight with all of us. So before we leave, we request you to kindly fill the feedback form as well that was shared in the chat box so that we can come up with much more meaningful sessions like this. And now let's take a virtual group photo. If the participants are convenient to on the cameras, please on your cameras. Let's take a virtual group photo. Participants. Yeah, that's okay. If you are comfortable, you can. Yes. Thank you. Thank you. I request everyone to kindly fill the form and if you are interested to accelerate programs, and you can fill the registration form that will be shared in the group, WhatsApp group. And now I really thank Chirag sir and the audience who showed their interactive learning experience in this session webinar. And thanks a lot. Thank you everyone for joining us today. And we'll look forward to seeing you again in the upcoming sessions. And have a great day, evening ahead, and stay connected with the Collective Council. Thank you. Bye bye.
Thank you.
Thank you, sir.